Aloha mai kako. I'm Scott Kalukukui, and welcome to our Better Together podcast. I'm here with attorney Christopher Dang, and we're going to talk about the who, what, how, and other things about estate planning. But thank you for coming and
You're
being
welcome.
here.
Thank you, Scott.
So let's start with the base fundamental question. What is estate planning?
You know, when I meet with clients, I think, or even prior to that, the word estate scares a lot of people.
Yeah.
It sounds like planning money.
Yeah.
And that's not the case. When we think about it, all of us have an estate plan. What I mean by that is when you're preparing, obviously you don't prepare for death, but you got to think about it. When we set up an IRA, when we set up a bank account, we name a beneficiary, or we have a joint account. That in itself is an estate plan in the sense that you know that when you pass away, that account's going to go to another person. So at its bare bones, that's estate planning. So don't be scared about the word estate, planning money. It has nothing to do with that. It's really about making sure that when you pass, have you thought about where things are going to go?
Okay. So one of the misconceptions is I have to have a lot of money to do an estate plan. Are there any other maybe misconceptions that you run into?
I think it's, they hear the term, I got to pay big taxes. And, this subject is so complex, but I'll keep it simple in the sense that people hear, I got to pay estate taxes. Not true. And, the laws will change. And without talking too much politics, the current exemption is $15 million federal.
Okay.
In other words, if you pass away with less than $15 million, you don't have to pay Uncle Sam.
Mm-hmm.
The state of Hawaii is a little lower. It's 5.5. When I say lower, though, that's 5.5 million.
Sure.
So anything below that, again, we're not worried about paying an estate tax. So, those kind of issues. Another common issue that I think scares people is that bad word called probate.
Oh, yeah,
Okay.
Right.
And in real life, and Hawaii legislature back in the 90s made probate process a little easier. That has, again, nothing to do with taxes. It's the state of Hawaii court system overlooking your shoulder. So if you pass, for example, and someone is appointed as your executor, that person is the one that's kind of going through the process, making sure things get to where they go. So that's kind of the probate process.
So we talk about this can be for everyone, right? I think the idea would be, what would you tell somebody to start seriously thinking about this? What would trigger them to start seriously thinking about this?
My clients range from 20-somethings,
Really?
believe it or not, that are single. And you would think, okay, that's the least, prospective client. You'd think that most of my clients are seniors. Not so. Most of them are, but I think it's, in terms of a financial, what's the starting point is, once you have, let's say, more than $100,000, in bank accounts or retirement, once you own property, even if it's a parcel on the Big Island covered by lava, might be worth $5,000. But once you own real estate, that's the consideration to start thinking about a trust. Now, there's a difference between a will and a trust. And so why I brought up that $100,000 rule is that's kind of what the trigger is to segue into a trust, because anything below that, if you don't own real estate and you have less than $100,000, a will should suffice.
Okay.
And again, different circumstances may necessitate a trust, but essentially it's anything below 100,000 will, anything more than 100,000 trust. So that's kind of the barometer.
Oh, okay. So that would lead into that question. So wills, trusts, is that all part of an estate plan?
Yeah, and the way I like to present it, we started again with the discussion of if you have joint accounts, or if you name a beneficiary on an IRA, if you have investment accounts where you name a beneficiary, yeah, that's planning, but that's kind of scatter planning in the sense that what if that beneficiary passes away? Or what if that beneficiary becomes disabled? And now you have this account where if you pass away, it goes to a disabled beneficiary, or that beneficiary is already gone. So it's not cohesive because you might have 10 different accounts out there. What a trust does is populate that, consolidates it, so that everything's dictated under the terms of the trust. And that's cohesive. So that's the word plan, right? In terms of planning ahead and saying, hey, I got this piece of property, I got this joint account, I got this IRA, I got this investment account. How does that all come together? And that's kind of planning.
Okay, so you help the people identify a lot of this and say, you need a will, you need a trust, you need other things as part of your overall estate plan. Is
correct?
And safe to say?
I think a key point too, and when I say estate again, it doesn't mean you need a lot of assets, but another thing about planning and another thing about trust is you've possibly heard the term living trust, revocable trust. That's something you actually create now. So that's prior to death. And so what I'm getting at is that, obviously if you pass, someone has to manage and make sure that things get where they are supposed to go. But even prior to death, if you become incapacitated, who's going to be taking care of your finances, your day-to-day, financial issues if you're incapacitated? And a trust addresses that as well.
Okay.
Yeah.
So if to the person out there says, I have a will, I'm good, what would you tell them?
Again, I would look at their financial circumstances. If it's below $100,000, a will is sufficient. But to that point, the key word is last will and testament. So a lot of people say, why do I have to go through this whole process? I'll just draw up a will. And I'll just share a quick example. A client of mine, walked in with slippers, T-shirt, and you never judge a book by a cover. Absolutely. In this area. And they sat down, looked through their finances, $15 million in net worth. So quite a bit. But he was a stubborn gentleman. So he goes, Chris, I know all about trust and all of that. I just want a will. So I had to, I said, okay, that's fine. It's still going to go where it's going to go. But remember, once you have more than $100,000, there's going to be a court probate process. There potentially is going to be an estate tax issue. Like I said, the $15 million, maybe not federal, but state of Hawaii, he's over that exemption amount. And his answer was, that's okay. I'm gone. So to certain people, a will is sufficient. I just think I just have to educate them as to the options. And so to this day, he has a will. No trust.
No trust.
No trust. So there's going to be a big probate procedure after he's gone, but he's gone.
So talk a little bit about probate and the I guess the negativity toward probate.
Yeah, and I think again prior to the late 90s when the legislature made what's called an informal probate procedure, people think, I got to go to court. There's a hearing. I got to show up again when the money's distributed. And that's not the case anymore. For straightforward probates now, where there's no potential contesting, maybe there's no conflict regarding a sale of a property, most probates are done informally, which means that I can apply to the registrar and submit an application. And probably within, if I file it correctly and doesn't get rejected, probably about 3 to 4 weeks or so before someone's appointed as executor.
Okay.
Another misconception is that people think is, I got to wait 2 years for that probate to finish before I receive anything. No, the executor during that period of time, in Hawaii it's called a personal representative, that person can begin making distributions. So, if you have some beneficiaries who need the funds or are waiting, you don't need to wait 2 years for a property to sell, for example. If there's some cash in the estate, then that can be distributed. And the executor, personal representative, can facilitate the sale of the property and eventually get it closed. So, it's that partial distribution.
So it's important to identify this executor in the documentation that you put together?
Yes. So in the will, or whether it's a trust, different terminology, but in the will, you're appointing who the personal representative is. And remember, it's a last will and testament. So I draw it up, you're going to put it on the shelf. You're not going to read it for 20 years, but when you pass away, the named personal representative will go to court if it's informal, mini court, but I'll appoint the personal representative. The registrar will say, okay, we'll give that guy power or that gal power. And from there, that person can begin closing accounts, can begin selling property. So it's pretty straightforward. And again, for relatively straightforward probates, you can even close it after 6 to 8 months. So it's really not that long or prohibitive anymore. But it does cost more to go through that procedure than it would be doing a trust, and having the planning done.
Well, because you often hear, well, at least I often hear, you don't want to go to probate.
Yeah.
Right? And is this the fear of that?
It is. It does cost more. It does take a little more time. And it is still involving the court. And so with a trust, you can be more creative in the sense that, for example, in a will, if you say, I pass away and it goes to my kids, it literally will just go straight to your kids when you're gone. You might say, well, what's wrong with that? That's what I wanted it to have happen. The issue with that is, what if your kid is financially irresponsible? What if your child has special needs? Right. What if you have a daughter-in-law or son-in-law that you cannot stand? It may eventually get in their hands. So with a trust, again, doing something during your lifetime that is essentially like a contract, you can dictate that after you're gone, it continues in a trust fund, for example, for the benefit of that special needs child, a trust fund for the benefit of that financially irresponsible child. Or in that case where you don't get along with your daughter and son-in-law, you have a trust fund where you have someone else managing it so that your son or daughter is not taken advantage of.
So you talked a little bit about the person who execute on the will or the trust, right? It's a large responsibility for the individual. So how do you go about choosing that person, approaching that person, and say, hey, by the way, can you do this for me?
Yeah. I tell clients, when we use that word trust, right, we're talking about the whole concept of estate planning. But when you think about who your trustee will be, who your manager will be, I say the first and most important thing is you trust that person. So it relates to the topic itself. It doesn't need to be a financial professional, because that's why I'm here. That's why the CPA is there. That's why the financial advisor is there, to guide the trustee. But it's a person that that's going to be diligent, responsible, and carry out the duties of what they're assigned to do. Another, I think, misunderstanding that people have is, I have 3 kids, and I don't want to name my oldest or my second because then the others will feel bad. Honestly, I tell the kids all along, good thing you're not the trustee. You don't have to do anything. You just got to wait for your brother. Brother's the one that got to do all the work. So it makes it a lot easier, when you have a person that you trust and is going to be diligent. It may be all 3 that you want to name, but practically speaking, if you have co-trustees, then all 3 got to decide, all 3 got to close accounts, all 3 got to sign paper so sometimes I tell clients, you know what, if your kids get along, just name the oldest. Or if they don't get along, maybe we better look at a third party, someone else outside of the family or a relative or a trust company to serve as a trustee if the kids can't do it together.
Yeah. So along that line, that brings up a pretty good one. In all of your experience, do a majority of the families get along, or do they not? That you
hit or miss. I get calls every day, and you can imagine, in today's day and age, there's a lot of second marriages, stepchildren, stepmom, all of that. So, and believe it or not, I always tell clients, I'm not a marriage counselor, I'm not a psychologist, I'm not, I'm a legal counselor. And it sounds blunt, but I'm not here to discuss your family problems. I'm here to help you navigate to get the money distributed.
Sure.
But it's always, you pushed me over riding the bike when I was 10 years old, and I remember that. So that's why I don't get along with my sister. Another common example in Hawaii, typical example, and I'm sure a lot of the listeners will relate, is when mom and dad are ill here, long-term care becomes an issue. And they're trying to take care of mom and dad at home. 2 kids live on the mainland. 1 child lives here. 1 child has given up their job to live at the home with mom and dad. So that, creates an issue where there's animosity, right?
Right.
Resentment.
Right.
Because the 2 on the mainland never really help out.
Yep.
I was the one who gave up my job and lived here for 30 years.
Yep.
They didn't care about mom and dad.
Right.
And yet the trust says divide 3 ways.
Right.
There's inherently going to be issues there.
Right.
If the family can talk it out, it's all under understanding. Maybe that child that does live here, there's an agreement that that child gets paid for their services. So it all depends. There's all different types of situations.
So when you meet with the family members, is that part of the discussion you have with them?
My client themselves are the parents. But a lot of times, if the family does get along, everyone will be there. And that's the best kind of scenario I like to see.
You would encourage the families all to be
Yeah.
in with this discussion so everybody's on the same page, correct?
Yes, to the extent that the family gets along. You'd be shocked too, though, in day-to-day practice, and my other colleagues, attorneys out there will speak for it, is I can already anticipate. Sometimes mom and dad come in with their wheelchair, sit down, you ask them a question, they're not really answering you, up to my son. And son's putting words in their mouth. So you got to be careful of the undue influence factor of it. Because, let me guess, this is me in my head thinking it is, let me guess, the whole house is going to go to this guy, right?
Yeah.
And, so I do ask a lot of questions. How well do the kids get along? And mom or dad hesitate. I said, what's that hesitation about? And a lot of times the friction between the kids, again, is the in-law situation.
Sure.
The sister-in-law, brother-in-law at the kid level. And that's what causes friction. The concern about, my son's wife. And the rest of the family knows that. But they can't tell him, we don't like your wife.
That's true. Right, true. But and part of it is also there is a cultural aspect to it, because I know in the Chinese family everything goes to the eldest son, right? And so how do you, generally, typically, right? So how do you navigate that?
Funny you say that. I'm 4th generation Chinese American. My parents are retired physicians. I'm the oldest of 7. So I joke with my parents. I'm like, hey, I'm the oldest child, so everything should just come to me.
But they don't practice that.
They don't practice
that.
That's
good.
So it's
that's
equal.
But there is, right? There are situations where you run into that.
Yeah. And I would say for the most part, that whole idea of the eldest getting it really it doesn't apply anymore. But when things go unequally, which is the case because of what transpired, I also have to talk to clients sometimes because they come in my office angry. I had a fight with my daughter last week, so take her out. I'm like, how about we meet again in like 3 weeks? You sure that this is going to be an issue that might hash over? And don't be so quick to remove her from the trust. I say, let's pause a little.
Sure, right.
But, just last week I had a client signing where she's been estranged, unfortunately, from her 2 daughters for decades. So yet she's the mom, and she doesn't want to, go to her grave feeling like she left her kids nothing. So the way we handled that was that, well, those your daughters have kids. Granted, those are grandkids she hasn't ever seen because her daughters keep them away. But in her heart, she wanted to make sure that at least if she didn't leave it to her daughters, she's going to have it in trust for the grandkids and have someone else serve as the trustee. So the daughters don't feel slighted.
Sure.
So that was kind of how we handled that.
So there are a lot of dynamics within your discussions with the family members. Some, if they don't, do you encourage the family members to all come in and so that?
I depending on the family dynamics again, I get a feel of what mom and dad are talking about. again, I'm just recalling all these meetings I
Sure.
have, even just yesterday. One lives on the mainland again. The son that I was meeting with lives in Japan, and he's sitting in front of mom and dad. I actually asked him to get up, to leave the room, and I wanted to make sure that mom and dad wanted to leave more to him. I wanted them to answer that and why.
Okay.
And I took notes on that.
Sure.
I allowed him to come back in after that, and he was good. He didn't say anything. He's not trying to direct them, but I try to encourage as much communication as possible so that there's no question marks. Because a lot of times, you set up the trust for mom and dad. I never meet the kids, and then it becomes a shock later. Or surprise because they anticipated that because I took care of mom and dad, I should have got the house.
Sure.
It just depends. If the family is capable of discussing that amongst themselves, if not, I encourage them to come out and talk about it.
I know in our line of work, we have to watch out for elderly abuse. So I would think you are probably in the same situation as well too, right?
And the problem for us, in the financial services is we're not physicians. So I can't make a medical diagnosis as to whether my client in front of me is incapacitated. But when I'm answering questions and they're not responding the way I think they should, or talk to my son about that. I said, no, I'm asking you, what do you want? No, talk to my son. Those are kind of situations that from an attorney standpoint, you don't want to get sued later. You need to be talking to the client and getting answers from the client. I asked, if son's there, I said, is there a medical record of incapacity? In other words, is there a physician's letter stating they're incapacitated? Is there onset dementia? Right? Is there Alzheimer's? And if such, I got to proceed cautiously. Doesn't mean I can't set up the trust. Obviously, if it's equal, the family's all sitting there, and mom's getting forgetful, we can still do the trust. Everyone knows about what the trust says, and it's all in the best interest of mom to get that trust set up.
Right.
You might say, well, she doesn't have her full capacity. It depends.
Sure.
And there's, unfortunately, some clients lawyer shop. And, I'm not going to talk bad about colleagues, but some are out there that I wouldn't have taken on as a client because, that's dangerous.
Sure.
But they'll make the change. And that's unfortunate because the person that son or daughter that wants that accomplished, say, Chris is not going to do it. I'm just going to go somewhere else and see someone else do it.
So within your discussions on estate planning with your clients, do you bring in their financial planner? Or what role does they play in all of this?
And it's like Lōkahi, it starts with the advisor. So whether it's the bank, whether it's the investment representative sitting at Lōkahi, that's kind of how it starts. My 30 years of practice, you won't see an ad from me anywhere in midweek or anything like that. It's just referral. And my referral base over the years has been financial advisors, CPAs, accountants, credit union, banks. Always happy to do podcasts like this, for example. But those are the ones who trust in my services, and it's a value added for your community,
right.
Your members. And so that's kind of how my practice has grown.
It's this partnership, right? Working together because everybody has a common interest to help the people through this process, right?
Yeah, we're all in the financial services area. I just so happen to be on the legal side. You folks are on the financial side, the banking side. But within that, there's also the CPA, the insurance person. It's all related.
So earlier you talked a little bit about the scenarios of what family members come to you with. How do you handle the decision when you have maybe the child or the person that's going to inherit from the parents and they are special needs?
Yeah.
And then so what does one do? If you can share a scenario with that.
I think that discussion usually starts, again, through referral, because the financial advisor, for example, says, hey, Chris, I have this client, but they do have a minor child or adult child that has special needs. And so the way that discussion started is still with the parents. And explain to me more. How old is the child? What are they high functioning? What is the level of care they need? Do they currently receive benefits from SSI, Medicaid, government benefits? And are there other siblings that you feel will be comfortable or responsible enough to take care of that child should you pass and take care of those finances? So those are the questions that I think swirl around, that particular disabled child or adult that we need to address, in the trust.
So at what point, because that's a little bit of a selfish question on my part,
Sure.
because my wife and I have a special needs son. He's 31 now, though. But we know quite a bit of people when their kids are in the teens or even younger. How do they begin? I mean, when do they begin?
Yeah. I don't want to get too technical, but the starting process, first of all, that's going to be foremost on the client's mind is I have this disabled child. If I pass away tomorrow, obviously we're not going to hand the house and the monies to a disabled child.
Correct.
And so that already brings up the context of the trust. But more importantly, and you brought it up, is there are special needs trusts specifically that can be designed. And the reason for that, you might say, well, why don't it just be a trust fund after I'm gone for that disabled child, and I'll have his brother or sister take care of it? That's good enough, right? The answer is no. There's a special type of trust fund post-death, or even you can create now that specifically says that the more common term is supplemental needs trust.
Okay, right.
So the key is that child will eventually possibly need Medicaid, SSI, or any government assistance. The inheritance, if you will, or what you put into that supplemental needs trust supplements what the government doesn't provide.
Correct.
So, if SSI is, let's say, the maximum of $994, or if it's slightly reduced, whatever that is, that $600 or $900 is not sufficient, obviously, to take care of all of the needs for that special needs child or adult. And that's where the trust will come in, because any monies distributed out of that trust to the beneficiary are not counted towards the elimination of those benefits.
Okay.
But let me clarify that is one of the rules of supplemental needs trust is you cannot give money directly to that special needs child or adult.
Right.
That's one of the no-nos, because that will jeopardize or even make you ineligible for Medicaid or SSI.
Because they can have no more than $2,000.
Yes,
right,
there's
in
rules.
their name, right?
There's
Correct.
rules. So, and some people might look at that and go, wow, that's kind of a legal loophole.
Yeah.
But it's not. It's established. It's in U.S. code. It's in state law. And it allows, again, the trust to be there to supplement. So if there's only $900 some odd dollars, and that's generally supposed to be used for food and shelter, then what about the cell phone bill? What about the Nintendo game or whatever it is? So the way the trust works is that whoever the trustee is allowed to distribute funds for the sole benefit of that child, not to that child, but the trustee is able to shop at Walmart, for example, to get the TV, to get the clothing, and that's all fine over and above the SSI, but it's all fine.
So to take care of their financial needs and their daily living needs, right? Correct. So I know that our discussion is about estate planning, but I see this as part of estate planning, correct?
Oh, yeah.
If you have a special needs child,
Yeah.
Do you work with people? Because there are people that we have run into that say, I don't know where to turn and when to turn, right? Because depending on the how high functioning or the kid is, at 18 they become adults.
Yes,
right.
And that's an excellent segue. Is when if you haven't thought about it in their younger years and now they're hitting teenage years, the key is 18. Right? Because regardless of whether your child has special needs or not, at 18, they've become an adult.
Right.
And the problem with that is you don't have any legal say anymore. So once they're 18, once you got to start thinking about this at 16 and 17, when your child's 16 or 17, you got to go through that guardianship process to have legal authority to act on their behalf as soon as they reach 18.
So you have helped some of your clients through this process?
Absolutely. I don't go through the application process, but I tell them ahead of time, hey, we got to start with, and I work with other attorneys that do the guardianship procedure. But once they hit 18, parents are legal guardian. There's a lot of programs out there for special needs children. Department of Health, Division of Vocational Rehab will get them set up and able to take care of that. But even the little things, right? Going to the doctor and having authority when you make that doctor's visit. If you don't have the guardianship papers, even as a parent, they're going to say, no, sorry, can't help.
Right.
So you got to have that guardianship in there.
Right.
I think another really important moment or segue is, with health insurance, right? Is because generally we can carry our children under our health insurance to 26. And so again, a few years prior to that, you got to start thinking about what are the options, because that child or adult child is no longer going to be on my health coverage anymore. I would say for federal employees, a lot of your members perhaps, there are ways in which if you have a member that's a federal employee, to get that child onto the federal program and be covered. So there might be dual coverage through Medicaid, but they will be on the federal coverage too. So that's another important milestone for a special needs child.
And you also help the families through the process and identifying, because it's a daunting. I mean, it's already challenging.
And I imagine you've gone through it. Like I said, your child's 31, and you have to kind of scrape up information for yourself to try to figure out what you got to do. But again, planning ahead. 18, if that's when they're an adult, you should really start thinking at 16 and say, what do I need to have guardianship ready? Obviously, you can't start the guardianship at 16 because you can't get appointed as guardian until they're 18.
Right.
But you got to start thinking about that.
But just being aware of the timelines and all the milestones that you need to hit.
Yeah.
I mean, because an estate plan, it's not a one-shot deal, right? I mean, as we start to look at, and all the discussion that we're talking about, how often should we be revisiting what we determine?
I tell you, obviously, if there's a huge change in the tax law that's going to dramatically, let's say, for example, I've been doing this 30 years. So in 1990s, the exemption was $600,000 from estate tax.
Oh, wow.
So in other words, again, if you have more than $600,000, you're going to pay a death tax if you die. I told you now it's $15 million. What a big change. I don't see, our current president is probably going to be out of office, will be out of office in 2028. We don't know who the next president is going to be.
Right.
We don't know what their agenda is. Are they going to lower the exemption? I don't foresee them lowering it a lot, but we don't know, right? So we have to plan. So if there's a big change in tax law, I'll communicate to my clients. But from the family side, it's change in family circumstances. Again, the marriage. Don't get along with daughter-in-law. Don't get along with son-in-law. Has there been a divorce in the family? Has there been a falling out with parent and child? Those are all the factors that necessitate maybe a review.
Okay. Because, this is, it's not cheap to do estate planning, right? But there are some costs, negative costs if you don't do it. Correct, and it could outweigh the what you upfront costs on this thing. Right?
Exactly, and estate planning is not expensive. I think it depends on the level of planning you need. But for most clients, just a fee range, and I can't speak for colleagues. But generally, you're looking at about maybe between $2,500 to $4,000 to get everything in place, the transfer property and the trust, and that don't quote me on that, because a lot of attorneys charge maybe a little less, maybe charge a little more.
But that's the ballpark.
And maybe I'm mistaken. Maybe I do just charge too low. I don't know.
Maybe.
I better check.
But it's really you're paying for a peace of mind, right? And
that is
you can't really put a price on peace of mind. Right?
That's the key. And I like to spend quite a bit of time in meetings with my clients, and I really appreciate it when they call years later and they say, "Hey, Chris, this is Shirley. Call me back." And I'm like, "Who's Shirley?"
Or you're too popular.
But they feel comfortable.
Yeah.
And that's the point, is that I'm their trusted advisor.
Sure.
I generally don't charge for phone calls or emails. I only charge when I actually do the work. So if they want to come into a meeting just to review, I don't charge for that, because I think it's good for me to know the changes to their plan too.
Right.
I'm not here just to write stuff, give them the invoice, pay me, and done. It's a relationship.
So that removes the barrier of
Yeah.
of cost. So somebody needs to continue to stay on this.
Because I think people are afraid to see a lawyer.
Yeah,
But
absolutely.
this type of lawyer is not litigious. My office does handle some unfortunate litigation where the trustee is getting sued because they're not doing their job, for example, or the beneficiary, for example, again is complaining about the trustee, or vice versa. The trustee has to be defended and make the statement that they're doing everything right. So that still rears its ugly head. I don't like doing that stuff. I like the harmony from the get-go, that everyone's on the same page and the plan worked.
Oh, yeah, right. Okay.
Yeah, and that's kind of, the whole idea of planning.
Yeah.
You got to think ahead.
Right.
You can't just wait to the last minute.
Correct.
Right.
Correct. So we're coming up to our time together. So all of what we talked about now, how does one start?
It starts with a relationship that your client might have, even with just Lōkahi, with their banker downstairs, with the branch manager, with the investment person they work with at Lōkahi. It's not just, again, transactional. It's not just, oh, here's your account, here's your balance. Have you thought about long-term care issues and your insurance? Have you thought about, hey, your child is special needs, and you can't just stick yourself on as a custodian. That's not going to be a perfect scenario for that child. And so I think it's the advisor spotting the issue. And, again, meeting with the lawyer is daunting. I don't charge for a consultation. Be happy to sit down and look at the situation and leave it up to the client as to whether they want to do some of this planning or not. Yeah.
So you don't, you can start any time, right? You said you had a client at 20, and it's not just all the elderly. Just start if you feel that you have the need for this, to reach out and start to have that discussion, right?
And again, it's personality, right? That 20-year-old who's not even married bought his or her first condo, and they have some IRA monies, and they say, I want a trust. I might even talk them out of it. I said, nah, you don't need it yet. We can, there's some ways we can, if you're worried about probate, or, honestly, if you pass away, you're 20-something years old, your parents are still living, you don't have kids, it's going to go to your parents,
right.
So again, it just depends on what they want to accomplish.
Okay.
Yeah.
Okay. Any last words of advice that you can give our audience?
Yeah, I think when you think about the word planning, don't get scared of the word estate. It's having the discussion, because I think there's that one adage that there's only two truisms, right, in life, is death and taxes. And so we can address both of those through proper planning. So that's, I think, something that, people should realize, is that the planning process will give you peace of mind, knowing that the whole process will end smoothly, as opposed to wondering, I'm sick now, and what's going to happen.
Yeah. I know thanks for the words of advice. Thanks for everything that you shared today. I know we could have talked hours more. There's so much more that we could have.
Absolutely.
But I really appreciate your time for stopping by. Much mahalos to Christopher Dang for stopping by to share his wisdom, his thoughts with us. If people want to contact you, how do they go about doing that?
Sure. Again, I work with Lōkahi, so the branch managers or the advisors here would probably know my name. That's one thing. Again, I'm not a marketing type of person, but if someone just Googles me and pulls up my name, you'll see my number, you'll see my office address, and that's a way to get a hold of me. I prefer email as the initial way to contact me, and I'll send intake sheet and try to schedule a meeting that way.
We look forward to partnering with you in the future.
Be glad to do part 2. Thank you.
Thank you.